Petruzzi versus Garden Art Innovations, and each side will have 15 minutes to present their arguments. And the appellant may have up to 5 minutes for rebuttal. The appellant just needs to let me know if that is desired. So, Mr. Is it Pilot?
Pilot, Your Honor.
Pilot. Oh, sorry about that. Mr. Pilot,
No
Attorney Pilot. Would you like to reserve some time?
Yes, Your Honor. If I could have 5 minutes for rebuttal, please.
That would be fine. And I always tell everybody, whether it's a criminal or a civil case, either one, just so it reminds me and reminds all the attorneys if they appear before us again in another case, we don't mention the names of victims. We don't mention the names of minor children. So with those caveats, we're ready to proceed.
Thank you, Your Honor. And may it please the court, I'm George Pilot, and I represent the appellant Jennifer Petruzzi in this matter against Garden Art Innovations. At its heart, this case is actually very simple. The defendant, Garden Art, did not comply with the terms of a cognovate promissory note and settlement agreement based on the explicit terms of the note. The trial court originally granted judgment after some procedural maneuvers by Garden Art, but then the trial court turned around and vacated the judgment, finding that there was a mistake by Garden Art in making its payment, and therefore that entitled it to be relieved from the terms of the cognovate note to which it agreed, and the consequence which was negotiated with the assistance of counsel. The case started off with a dispute between the parties over $50,000 that Jennifer Petruzzi claimed she was owed as a result of her employment relationship with Garden Art. The parties then had communication, counsel had communication, Mr. Miller represented Garden Art, and they came to a settlement which would enable the defendant Garden Art, instead of paying the $50,000 that Ms. Petruzzi claimed was owed, they would be able to pay $35,000 in 6 monthly installments with no interest. The terms of the settlement were then memorialized in a written settlement agreement, as well as a cognovate promissory note that explicitly set forth exactly to the penny how much each payment was supposed to be, the deadline for each payment, and then Ms. Petruzzi even allowed the defendant just to have the payments postmarked by the due date in order for them to be deemed received timely. The agreement and the terms of the cognovate promissory note also provided a specific and unique remedy if the defendant failed to comply. And that stated that if Garden Art defaults in any term or condition of the note, including but not limiting to failing to make any payment on time or in full, then the obligation will automatically increase to $50,000, less any payments previously made, plus interest at 18% annum calculated from the date of the note, plus attorney's fees and expenses. There is no dispute that that term was contained in the note. There's never been any argument that it is somehow unclear or ambiguous, and Garden Art agreed to those terms as part of signing the note and the settlement agreement. Garden Art then made the first few payments under the note on time and as directed. The problem came up because it did not make all of the payments in full. Garden Art shorted the last payment by 2 cents. At that point, Ms. Petruzzi had the absolute right under the terms of the note to take judgment on the note because Garden Art had defaulted. They had breached, they had not complied. They were subject to the exclusive and unique remedy that they had agreed to while being represented by counsel. And that was then, Ms. Petruzzi sought to take judgment. The Garden Art then, before judgment could be entered, managed to file for a temporary restraining order. A clever move, and I'll give him credit for that. I'll give Mr. Miller credit for doing that, which then delayed entry of judgment. After briefing, the trial court entered judgment, said that there was no reason why the cognovate judgment should not be entered because the defendant clearly had breached, had not complied with the terms of the note, and the judgment should be entered. Garden Art then turned around and filed a motion for relief from judgment, claiming that the failure to make the final payment in full was simply a mistake by Mr. Bradley, and therefore they should be relieved from the judgment that had been entered. The trial court said that, well, since the mistake by Mr. Bradley in making a payment in full by the due date was a mistake sufficient to vacate the judgment under the terms of, under the provisions of Rule 60B. And Garden Art had argued as well that they had substantially complied with the terms of the note, and therefore there was no basis, there was no breach then, which the trial court had already rejected once, and that should relieve them from the terms of the note. There was no case law that has ever applied that's the concept of substantial compliance in the form of avoiding judgment under a cognate note. The trial court, when it said that this type of mistake in failing to make the payment in full as required under the explicit terms of the note, it cited no case law that would justify using this negligent failure by the defendant to pay the note in full, would justify using that as a mistake under Rule 60B. The court cited no cases because there are no cases. There is no case law that stands for the proposition that one party's negligent failure to comply with the terms of a promissory note is the type of mistake that justifies granting relief from judgment under Rule 60B.
Counsel, I just want to double check. So the only issue in this case is the lack of a 2-cent payment.
That was the amount that the payment was short, which then entitled Ms. Petruzzi to the additional relief that was provided for in the note. That, yes, so the payment, the total amount of payments were short by 2 cents. And that was what triggered then the right to take judgment, because the note had not been complied with as it had been drafted and, and agreed to. The unilateral mistake of one party from its own negligence in failing to comply with the terms of the contract is not a basis to grant relief from the judgment under the mistake provision of Rule 60B1. One other part that also is troubling with the trial court's decision and its findings is because it seemed to attach terms to the note and the parties' agreement that they did not agree to. The trial court mentioned the fact that, well, the Garden Art had made its final payment early, and that even though it was 2 cents short, that Ms. Petruzzi or her counsel never contacted the Garden Art to let them know that they were short by the payment, essentially attaching some type of notice or opportunity to cure in the note that was not there. The trial court has no authority to be reforming a contract that is clear and unambiguous by the parties. There's no duty that Ms. Petruzzi ever had to have contacted Garden Art to say, hey, by the way, you're short by 2 cents. Can you send me that before the deadline? The burden was always on.
This is an abuse of, excuse me, this is an abuse of discretion standard. The court clearly thought that was a mistake. Why would they not pay the full amount when, full $50,000 judgment if they didn't pay the amount in full and the payment was made early and it was 2 cents short? Don't all those facts support court that this was a mistake and that there was not an abuse of discretion?
I was having trouble hearing a little bit of that, Judge, but the case law is that the mistake based on a party's own negligence in failing to comply with the contract is not sufficient to justify relief from judgment under Rule 60B1 standard for mistake. That's where the abuse of discretion came in, as well as the court disregarding or essentially taking evidence that had already been presented and rejected, and then accepting that after the fact as evidence to justify vacating the judgment when it had rejected that evidence for purposes of entering the judgment in the first place. That's also part of the abuse of discretion. And I would say also essentially reforming the note and focusing on a lack of conduct or some supposed duty on the behalf of of Jennifer Petruzzi or her counsel to have communicated with the defendant and let them know that they were short, as well as then post breach and default communication where I had communicated to Mr. Miller that we were making demand for the full amount that was due under the note, the $50,000 less the payments they had made, and that somehow the court felt that, well, we should have accepted 2 cents at that point, essentially waived the default and just gone about our way. That somehow Jennifer Petruzzi should have waived her rights that were negotiated as part of the settlement agreement and the cognovant note to not require compliance with the note that again was agreed to by counsel. Again, the trial court seeming to put the fault somehow on Ms. Petruzzi that the defendant did not comply with the note that it agreed to, that was explicit, that was clear, unambiguous, and which had a specifically negotiated remedy for a breach and a default. And that's exactly what—
Mr. Pilot, you're into your rebuttal time. Do you want to save that, or do you want to continue arguing now?
No, Your Honor. All I will say is that we'd ask that the court reverse the judgment of the trial court and reinstate the judgment against Gardner. Thank you.
Thank you. Attorney Miller, you may proceed.
Thank you, Your Honors. May it please the court, my name is Matt Miller. I am counsel for Appellee Garden Arts Innovation, LLC, and we respectfully request that this court affirm the trial court's ruling granting Garden Arts' motion for relief from judgment. A thorough review of the court's order granting the motion for relief from judgment demonstrates a reasoned and comprehensive review of both the law and the facts, and demonstrates that there's no abuse of discretion. It's not unreasonable, it's not arbitrary, it's not unconscionable, and Ms. Petruzzi has failed to demonstrate in any way or manner that the trial court's decision was in any way an abuse of discretion, which is the standard in this case. We know that the Ninth District has emphasized that in a motion for relief from judgment of a cognovant note, it has to be pursued timely and in light of a proper allegation of a meritorious defense, and that any doubt should be resolved in favor of setting aside the judgment so that the case can be decided on the merits. Courts disfavor cognovant judgments, and they want these cases decided on the merits. So in this case, the only issue is whether there is a meritorious defense. And I think this is where we seem like two ships passing in the night, and we're talking about two different things. Ms. Petruzzi is arguing that the trial court somehow relied on mistake. Mr. Pilot mentioned the word mistake no short of 20 times during his 10-minute argument. Mistake is not what has been argued. We have argued from day one that there is non-default. It is substantial compliance. There are limited defenses available to a cognovant judgment debtor when seeking relief from judgment under 60B. Payment and non-default are two of those. The Ninth District has affirmed this. And Ohio law is crystal clear in this part of the law. If there is substantial compliance, there is no breach of contract. If there is no breach of contract, there is no default. Accordingly, Garden Art presents a meritorious defense, and that's all that's required under 60B. We don't have to prove the meritorious defense, we just have to properly assert the meritorious defense.
Counsel, you're speaking to Ohio case law relative to contracts generally. Is there Ohio case law that you can point to related to cognovant notes?
Yes, Your Honor, and this is part of my apology. We did not cite this case in our briefing, and I know Mr. Powell has harped on the fact that there is no case law. It is Jacobs v.
Counsel,
Hayba.
counsel,
Yes, Your Honor.
you know our rules in regard to notifying
Yes, Your
people
Honor.
beforehand about that. If there's any law in effect in regard to this, the court will be able to find that.
Thank you, Your Honor.
It's just not fair to the other side to try to argue against the case that's never even been cited at this point.
Agreed. Suffice to say, the case law does exist. And contract law is crystal clear that substantial performance equals no breach of contract, equals non-default. You substantially perform a contract, you do not breach that contract, and there's no default on your part. And appellant has harped on the fact that there is no case law rejecting substantial performance. There's no case law accepting substantial performance. He's saying there's no case law. The case law does exist. Applying it to the facts of this case, it's a textbook example of substantial performance or substantial compliance. Substantial performance of a contract is interpreted to mean slight departures, omissions, and inadvertences, and they should be disregarded. Merely nominal, trifling, or technical departures are not sufficient to breach the contract. The trial court held that the underpayment of the 2 cents was a mistake. It was inadvertent. It was a nominal departure. They weren't saying it was a mistake. They're saying it was inadvertent under the substantial compliance rules. So the question is the alleged breach, is the omission of 2 cents material? It's not. It does not breach the contract. It does not destroy the value or purpose of the contract. This court recently held that for the doctrine of substantial performance to apply, the part unperformed must not destroy the value or purpose of the contract. And the application of the doctrine of substantial performance should be confined to very narrow limits and to cases where there has been an honest effort to perform. Mr. Pilot demonstrated the honest effort to perform on behalf of Garden Arts. Garden Arts was to make 6 separate payments of $5,833.33. Excuse me, the first 5 payments were $5,833.33. The last payment was $5,833.35. Mr. Bradley was mistaken and wrote the last 2 checks a month early. Both checks in the amount of $5,833.33. He was mistakenly 2 cents short, and the court said that is a slight departure. That is a nominal omission of 2 cents that does not destroy the value of the contract. And Ms. Petruzzi waited. Again, she received the last 2 payments in before December 30th. The last payment was due January 30th, 2019. Ms. Petruzzi waited until February of 2019 to notify that we were 2 cents short. The 2 cents were immediately sent to counsel. Counsel then waited 10 months to file a lawsuit alleging that we were in breach of the contract. That's waiver as a matter of course. Further, appellate has waived all arguments with regards to substantial performance. They, in their initial brief, they denied that we even argued non-default and substantial performance. In their reply brief, they did not answer yay or nay whether or not substantial performance applied. All they said was there is no case law. They've tacitly admitted that substantial performance or substantial compliance applies in this case. 2 cents short is a textbook example of substantial performance under Ohio law. And as a result, Garden Art Innovation LLC requests that this court affirm the trial court's granting of Garden Art's motion for relief from judgment. And with that, if the court has any questions, I'd be happy to answer them. If not, I will yield the remainder of my time to the court.
Any more questions from the panel? Seeing there are no questions, we'll go ahead and go to rebuttal with Mr. Pilot. You have 5 minutes.
Thank you, Your Honor. And again, may it please the court, I'd like to just hit a few of the points because the Garden Art's arguments are internally inconsistent and actually contradicted themselves several times. The trial court never ruled on the issue of substantial compliance in connection with its order agreeing to vacate the judgment. That was not mentioned at all in the trial court's decision, that it was relying on substantial compliance with the terms of the note to relieve Garden Art from the remedy which it had agreed to and was explicitly set forth in the note. And in fact, the trial court's original decision in which it entered the judgment on the note cited, the magistrate cited, in which the trial judge then affirmed or approved, said that absent complete compliance with the terms of the note, a party cannot avoid a judgment on a cognobit note. The defendant has admitted, Garden Art has admitted, and there is no dispute anywhere, they did not comply with the terms of the note. They've argued substantial compliance. The trial court did not rely on that at all in making its ruling granting the relief from the judgment. Although Mr. Miller said in one breath that the trial court never relied on mistake, he then a few minutes later said that the trial court did say that the failure to make the payment was a mistake. And in fact, that's exactly what the trial court relied on in making its judgment vacated, making its order vacating the judgment, was that this was a mistake, not substantial compliance.
Counsel,
Yes, Your Honor.
is there a difference between making a mistake in writing a check in the wrong amount if you intended to write the check in the correct amount and didn't realize? In other words, what they're saying here, I think, and correct me if I'm wrong, and maybe I'm missing the point, is the intent was to make the payment, and even to make the payment early. It was just a matter of almost like a nunc pro tunc we use in court when the wrong thing was written on the judgment entry, and as opposed to what was said in court.
Well, and that's where I would say there's 2 points to that, Your Honor. Number one is that where the terms of a contract or a note are explicit, those must be complied with. That's clear. And a party's own negligence in failing to do something to comply with the contract does not relieve it from the obligations that it has under the contract. And again, any party then could come in and say, well, I breached, but it was a mistake, so therefore I shouldn't be held to liable for the breach, or in this case, held to the specific remedy that the parties had agreed would apply if there was not exact compliance with every term of the note. The note itself says if any payment is not made on time and in full, it was not made in full. They did not comply with the terms of the note, and it was their own negligence that caused that, whether it was a mistake, and whatever it happens to be, that is not sufficient to warrant a relief from judgment.
Would it be appropriate, though, to maybe examine what a complete payment is?
Well, the complete payment, and that's where the note is very explicit as to what constitutes full payment. It says $35,000. It says exactly how much is to be paid each month by a specific due date, and that was not complied with.
And how does the law enter into it, the law that says, the cognobit notes are disfavored? So you're saying there can never be any equity whatsoever. If it was only a penny, it wouldn't have mattered. 2 cents, you have to admit, is pretty minuscule.
It is a minor amount in connection with $35,000, but in order to affirm the trial court, for example, to say that, well, 2 cents, it was well, then number one, any party could say that's a mistake. Is it 2 cents that's the standard? What about $1? What about 5 cents? I mean, then the courts are left with determining at what point they should potentially relieve a party from a cognate judgment when its own negligence has caused a breach of the note and an admitted breach. I know they'd say, well, substantial compliance does not mean a default. However, they've admitted they did not comply with the terms of the note. And that in of itself means that they're subject to the remedy that's set forth in the note. The trial court originally entered judgment properly and then turned around and used the mistake language in Rule 60B1 to relieve them from that, when what they did was not a mistake within the context of Rule 60B1 to warrant a relief from judgment. The trial court never applied substantial compliance. It never reached that issue and never ruled on that because it held there was no defense to the cognate note that was not complied with in full. It relied instead on the mistake concept, which for which there is no legal authority to make this type of mistake sufficient to grant a relief from judgment.
So is your argument that 60B1 would never apply to a cognate note? Is that what you're arguing?
No, 60B1.
A mistake can't. The mistake language in 60B1.
I'm sorry, Your Honor, for jumping in there. The mistake language under 60B1 would not ever apply to this type of situation where the party, where the breaching party is claiming a mistake to avoid it from a cognate note, because typically the mistake case.
Well, let's say the scenario is he forgot the stamp on the envelope when he mailed that last payment. It arrived after the due date. 60B1 save him in that situation?
Counsel, before, I'm sorry, I had to talk over you because I want you to know in answering this question, you are already completely out of time. So I want you to answer Judge Studos's question and not proceed further. Thank you.
Understood, Your Honor. Thank you. I would say in the context of Rule 60B1 and as it applies to the express terms of a note, I would say no. In that instance, 60B1 mistake standard would not relieve the party of a judgment for that reason. Thank you.
Thank you. Thank you both for the arguments you've made to the court and the presentations this morning. We will take the matter under advisement and we will issue both sides a written opinion that will be sent to you. And we also release our opinions online through our website and the Supreme Court website. The next oral argument, video argument, I should say, is scheduled for Tuesday, 9/14. So if anybody wants to tune in, we'll be here. All right. Thank you both, gentlemen. We appreciate it.
Thank you, judges.
Have a good day.
Thank you.